Welcome to our on-demand session, Get Your Ducks in a Row, the Estate Planning Process. My name is Melanie Reyes, and I will be your host for this session. A few things before we get started. It may be helpful to have a pen and paper handy, or even opening up a Word document or a notes app on your phone to be able to take notes as we go through the session today. Before we get started, I do want to take a moment just to share a little bit about Summit Credit Union and why we choose to prioritize financial education. And that's because we believe that no matter where you are at in life, making smart choices really is the key to being financially successful. And that starts when you have the right tools, the knowledge, and the resources. Now, Caring.com shared that 33% of Americans have taken the time to document their wishes and plan for how their assets will be distributed. That means that 67% of Americans have no estate plan in place. The biggest reason per the survey for not having an estate plan in place is that they have not gotten around to it. Now, working in our branches for several years, seeing the impact caused by no pre-planning, along with seeing the impact firsthand in my own family, taught me the importance of getting your ducks in a row. Now, we created this session to help you prepare for the unexpected so that your loved ones can work through your financial affairs with less overwhelm. We will explain and share what you need to know, along with providing you steps to take so that your assets are divided based on your wishes. We will share key terms, how to document appropriately, and steps you can take to prepare the best you can to bring you the utmost peace of mind. So let's get started. I'm sure many of you have heard of the term estate planning. Estate planning is the preparation of tasks that serve to manage individual asset base in the event of their incapacitation or death. It can often be daunting and overwhelming at the same time when thinking into the future and how to make decisions that will impact your financial and your family affairs. It is also something that seems out of reach for people because of the perception that it costs a lot of money. To really break it down further, estate planning is simply you writing down and organizing your personal financial assets and possessions and what you want done with them when you pass away. When you do this, it helps you prepare for the unexpected so your loved ones can work through your things with less overwhelm. I recently contacted the Register of Deeds and found out that you can do a transfer on death on a home with a $30 fee. This was new to me, and sure thing, when I checked into it here, it was an option. Now, I will not be covering transfer on death in this session, but I did want to share my recent learning and tie that into this session as it is a part of the estate planning process. The estate planning process includes things like your last will and testament, payable on death, power of attorney for healthcare and finances, trusts, and also funeral planning and declaration. Now, there are a lot of options that can help you prepare and so much to know. We will cover as much as we can in this session, along with advising that you connect with trusted professionals following this session who can help you put your mind at ease as you go through this process of getting your ducks in a row. A will is a legal document that communicates a person's final wishes pertaining to their assets. It explains what you want done with your property, including homes, cars, household items, sentimental pieces, and more. It could also cover the care of your children following your passing. Many people wrongfully believe that a will covers or supersedes anything listed on their financial accounts. And a will does not. It actually is a very common misconception out there that we wanted to address today and to help you prepare your accounts so that the people you want to get your money will get it. If you pass away without a will, your estate, including the distribution of your assets, will be settled by the courts. If parents with children pass without a will, the courts will appoint a guardian for those who are minors. A valid will requires that you understand what property you have and what it means to leave property to others after your death. For a will to be considered valid, it must be signed, and many jurisdictions also require that the signing of a will be witnessed by two unrelated individuals who are 18 years of age or older. Wills can be drafted affordably using an online will maker and or contacting an estate lawyer. It is recommended to update your will each time you experience a major life event. When my two older children turned 18, I updated my will and my wishes to change who would be my executor of my estate. I originally had my mother listed, but as she has aged since I had first written the document, it really made sense to appoint one of my own who are of legal age now. I also know someone who recently lost a spouse, and due to the will not being updated, the ex spouse ended up receiving all of the inheritance. This is why it is so pertinent to keep all of this information top of mind. A payable on death is referred to as a POD, a beneficiary designated by the owner of the account, or it could be owners, to receive the balance of funds when the last owner on the account passes away. Payable on death, again, POD, is an arrangement that an individual makes with financial institutions to designate beneficiaries to their bank accounts or certificates of deposit. It is very easy to add a POD to your account, which is a cost-free service. Adding a payable on death provides easier transfer of your bank accounts following your passing. You're able to add more than one beneficiary at a time as well. With myself having 3 children, I chose to designate the split amongst 3 of them at 33.3, 33.4, and 33.3 to equal 100%. Now, you can request this form at your bank or credit union, and it can generally be completed within a few minutes and the account updated to reflect the change instantly. One thing to note is if the account is jointly owned by more than one person, a named beneficiary cannot access the funds until the last owner passes away. In this case, the assets in the account, which is joint, would be turned over to the joint owner first, and the beneficiaries named will be granted second by the last surviving owner. A power of attorney is a legal authorization that gives a designated person the power to act for someone else. A power of attorney is only in effect as long as the person is alive and can be added if the person is competent and able to understand and sign. There are 2 types of power of attorneys: power of attorney for healthcare and power of attorney for finances. A healthcare power of attorney, which is an HCPA, is a legal document that allows an individual to empower another person to make decisions about their medical care. A financial power of attorney is a legal document that lets you appoint someone to manage your finances and property for you. There are 3 main roles of a power of attorney, or a POA as it is referred to: the ability to make decisions on behalf of someone who has lost their mental capacity, ability to handle legal and financial matters on behalf of them, and the ability to make medical decisions on their behalf. Now, here are some things that a power of attorney, can do here at Summit: open and close accounts in a member's name, withdraw funds from another member's account, endorse, write, or cash checks on behalf of a member. A living trust is a legal arrangement established by an individual, the grantor, during their lifetime to protect their assets and direct their distribution after the grantor's death. Per Investopedia, it is the estate planning tool that can help family members and beneficiaries avoid a lengthy, public, complex, and sometimes a costly probate process. Unlike a will, a living trust takes effect while the grantor is living. A living trust lays out all of the terms of the trust and assets, designating a trustee who will have a specific direction on the distribution of assets following death. Living trusts can be either revocable or irrevocable, which have differences in the terms of tax, and some choose this option, which bypasses the probate process. Trusts and financial accounts, including life insurance policies with named beneficiaries, do not pass through probate court. A revocable trust can be changed at any time by the grantor during their lifetime as long as they are competent. Now, an irrevocable trust usually can't be changed without a court order or the approval of the trust beneficiaries. This makes an irrevocable trust less flexible. For trust questions, it is recommended to consult with an estate planning attorney. Now, we all know that death is inevitable. It's something we cannot escape. So some choose to include funeral planning in the estate planning process to make things a little easier on their loved ones. Funeral planning is the act of making arrangements for final disposition, including funeral, cremation, memorial, ceremony, or other service plans prior to death. When you pre plan, it allows you to make your wishes known ahead of time without requiring family members to make these decisions. Too often, there are disagreements on decisions for loved ones when it comes to funeral planning, especially when one has passed. You are able to personalize the experience by choosing your disposition of cremation or burial. You can also share your preferences, for ceremony wishes such as funeral service, memorial, visitation, and more. You can also choose your final place of rest, and this may be a burial plot or cremation and your wishes following. You're also able to make pre-arrangements with paying for burial plots, service costs, and more. And this is typically through a second party through the funeral home. You can also stop by a funeral home or look online for pre-planning guides and processes. The titling on your accounts is essential in the estate planning process. This covers financial accounts like your savings, checking, certificates, money markets, individual IRAs, as well as your safety deposit boxes. You should update your accounts after life events like the birth of a child, or deaths, or even divorce, or any other major life events that happen. Now let's talk about two examples of how the names on the accounts matter when it comes to passing along money after someone has passed. In the simplest of explanation, here is what happens. If you and your joint account holder have an account together and one of you pass away, the other automatically continues to have access to the funds in the account, which is called right of survivorship. If you or your joint account holder both pass away at the same time, the beneficiary on the account would get the money. The beneficiary is who the account owner names to get the money if they were to pass away. If you are the only person on the account, your money will go to the beneficiary that was listed on the account. Now, if you do not have a beneficiary on the account, the process will need to go through probate court. Now, with safety deposit boxes, these can have different signers and beneficiaries than on the accounts. And it will be important to know how that is handled as well when it comes to titling on a safety deposit box itself and who is granted access. Let's look into probate. Probate is the process completed when a decedent leaves assets to distribute, such as bank accounts, real estate, and financial investments. If someone has a will when they pass away, they will have to go through the legal process to verify that the will is legal, and it gives the executors of the will permission to do your loved one's last wishes. This process protects family members and makes sure that the intentions of your loved ones are honored, and it ensures that all debts and taxes are paid. If there is a will, the court will use the will to determine who is appointed executor of the estate. This is the person who will carry out the terms of the will. When someone passes, you will need to contact probate court to file their will. Typically, this happens within a week to 10 days following death, as you might need to access funds to pay bills, etc. Now, there are also some information and documents that you would need to prepare for probate court. The deceased full name and date of birth, a certified copy of a death certificate, which can take longer than a week or two, a will if there is one, a copy of a marriage certificate if the deceased was a spouse. If the deceased was previously married, you would need to supply that information as well to the court. The name and address of all the heirs, next of kin, and beneficiaries, and a summary of the deceased assets. Now, how long the probate process takes really depends on how large and complex the person's assets are, as well as the estate process, knowing that it could take months or even years to settle, really dependent on the size. And it also depends on the state's probate laws. Now, here's what happens if there are no beneficiaries on your financial accounts. The court will appoint a personal representative usually a spouse or a relative, to act as executor. An attorney or a financial institution may also be appointed as an executor. The person named to handle the affairs needs to take the official will and the death certificate to probate court and file a probate petition. The court will open a probate file and validate the will. They will determine the executor of the estate from the person named in the will and give authority to handle the affairs and act on behalf of the deceased in accordance with what they will do here by thoroughly going through documents and issuing a letter of testamentary or a domiciliary letter. Many people call this also a personal representative or an executor of the will, and you will have a legal or moral duty. This can be a very long process, and we don't want your loved ones to have to go through this for your financial accounts. That is why you need to make sure the titling on your accounts is how you certainly want it. Now, here's a tip. We encourage everyone to review all of your financial accounts, your investment accounts, retirement accounts, and insurance policies to determine which ones are joint, which ones have beneficiaries, and to determine if these are indeed your wishes at this time. Now, there are times when family members come into the credit union expecting immediate access to funds to use loved ones' savings and checking accounts to pay for funeral or other expenses because they have a copy of the will. We know this can be an extremely hard time, and piecing together loved ones' finances and working through them can be very stressful. It is important to note that as a financial institution who has a legal agreement for financial accounts with someone, that we are bound by law to give money to whoever is listed as beneficiary or payable on death on the accounts, regardless of what a will says. And it is a common misconception. This means that it is really important that you spend time to make your wishes known and to check your beneficiaries. It is really important as your relationships change during your lifetime to review these documents and when your minor children become adults as well. Think about it this way. Just as you take the time to pull a copy of your credit report yearly to check for fraud and your accounts that are listed, you should be reviewing your beneficiaries and your accounts as well. We have created a Get Your Ducks in a Row worksheet. You can utilize this worksheet to help you through the estate planning process as a guide. We suggest providing a copy to your executor for safekeeping and for understanding. Now, payment protection is an insurance that pays for all or some portion of an outstanding loan. Now, the first step to determine whether there is payment protection on a loan would be to reach out to the financial institution to really understand if there is any additional protection added. If there is, you would be able to file a claim and submit paperwork, certainly on behalf of the person that passed away. Once the claim is filed, it can take 30 days for processing. If there is no payment protection or the payment protection does not pay off the balance, the co-borrower, the co-signer, or the member's estate will be responsible for the balance. Now you might be thinking, what about if my loved one has a loan out there? What happens to the loan if there is money still owed? If the loan does not have that payment protection, or maybe it just pays for a part of it, again, there is a responsibility by the co-borrower or the estate. If you are joint on credit cards with a loved one, the loved one can keep the account open and continue to use their card, but destroy the loved one's card. Or if they decide to close the account, they can certainly establish a new one in an individual name, but there is responsibility for the remaining balance on the account and the money owed on the credit card or card. Now, open communication is really important with family members. We recommend sitting down with those that you select as beneficiaries and executors to get their support. It is essential to keep them involved in the process with information and as you make updates and changes. Now, here are some tips to certainly take away. Use your Get Your Ducks in a Row worksheet and share copies with your loved ones. Schedule a reminder every year as a check-in or change items that involve your estate planning documents. And this could be scheduling a reminder on your calendar either every 6 months or every year to revisit your documents. And then also prioritize takeaways from today's session so that you can have the peace of mind that you ultimately deserve. Now, as we come to a close today on this webinar, I wanted to leave you with this quote. Estate planning is an important and everlasting gift you can give your family, by Susie Orman. Now take a moment to reflect here on what ducks you need to prioritize as you have gone through this session. We thank you for joining this on-demand session today of Get Your Ducks in a Row, the estate planning process. You are welcome to email us at financialwellness@summitcreditunion.com with any questions that you have, or if you would like to be connected with a complimentary coach. Thank you so much for joining us for this session today. Be well.